I think in the case of countries such as Antigua and Barbuda, the answer to your question is that we are very happy and proud to serve them as their final court of appeal, if and so long as they wish us to. In this modern democratic age, every country has ultimately to decide democratically what its fundamental constitutional features are. And if a country such as Antigua and Barbuda decides that it wishes to delink, then once that decision is appropriately constitutionally and democratically taken, then it should delink.
We're conscious of the inevitable expense in travelling to the UK and obtaining visas and accommodation, or indeed instructing counsel in the UK, and I can come back to this point.
I think that any court has a certain amount of mystique because people have to respect the court, and when they give evidence or when they come and appear in it, they have to respect the court. But I think mystique which makes people frightened or means that they don't understand what goes on is not right. And I think what the Judicial Committee of the Privy Council has been doing over the years, and if you go back into the mists of history, as Lord Mance described, has succeeded in doing, is to bring itself up to date from time to time. And while I appreciate in particular that if you are in Antigua and Barbuda, you look 3,000 miles away to London, it looks a bit far away, we do try and make ourselves as available, as transparent as any court can be. And one of the purposes of us being here today is to try and explain and blow away any misconceptions about the Judicial Committee of the Privy Council. What we do is perfectly simple. We hear appeals from countries, from states which are happy to come to us and treat us as their final court of appeal, which is a great honor for us. And we want to ensure that citizens, companies, governments, individuals who want to come from those countries to our court, to the Judicial Committee, feel that we are there to serve them, there to hear their cases, and there to give judgments which we hope are readily understandable. And we do not like the idea of having much mystique, and do our best to try and avoid having it.
But it's not actually necessary to instruct Privy Council agents over here, for example, and of course it's not necessary to instruct UK counsel. We very much welcome overseas counsel from the relevant jurisdiction, and we do see quite a lot of them, I think in 60% of cases. We do have provisions in place to ensure access to justice. For example, in criminal cases, there are no fees payable to the JCPC. In civil cases, the fee does depend on the value of the amount in issue. And we do, in the Privy Council, see a very wide range of cases. We see cases ranging from heavy commercial cases, constitutional cases, down to quite small cases. So the amount of cost in terms of fees is, to the court is very much dependent on that. There is power, and it frequently is exercised, in the registrar to waive court fees to parties who can't afford them. But it's certainly something we see quite frequently where individuals say that they cannot afford it. The registrar has that discretion, and if need be, it's reviewed by justice. There is also a facility for UK counsel to be asked to act where a local party simply can't afford any sort of representation here, to act free of charge as a sort of amicus curiae, and we have used that on a number of occasions.
I think it's also relevant to say that our offer of video hearings should reduce costs very considerably when it's taken up. It hasn't been taken up very often, and maybe we should make it more publicly known and more clearly known that it's available. But we are very happy to have hearings with the advocates and the parties and the solicitors in Antigua and Barbuda, and the judges here having a hearing a bit like the present interview is taking place.
It's about, I think, 25 or 30 cases a year. most of those, I think about 2/3, come as of right, and sometimes the limits in local constitutions are quite low, I think generally so, but the rest come by permission and depend upon application to us. I suppose about 20 or perhaps 25 applications a year, of which we grant 1/3 on average. Remarkably consistent average, actually, not by intent, but simply by considering each case on its merits. It works out at about that.
As for the rate of disposition, it depends to some extent on, first of all, how long between the appeal being lodged and the hearing of the appeal, and secondly, how long it takes to produce the judgment. But in 1 or 2 cases where the matter's been urgent, we've managed to dispose of it very quickly. Lord Mance, for example, had a case recently which was very urgent and was disposed of, he will tell you how quickly, very quickly. When it comes to the gap between the start of the issue of the appeal and the hearing, to some extent it depends on the availability of counsel. The advocates and the solicitors sometimes want the hearing delayed, sometimes the parties do. But when it comes for the gap between the hearing and the judgment, it's normally a matter of no more than a couple of months. On difficult cases involving lots of facts, where there may be disagreement among the judges, it may be longer, and on urgent cases or small cases, it may be shorter. But I think Lord Mance can give you an example of a very quick disposal of a case.
Yes, I can probably give 2 examples, but we do deal with matters on paper when they're interlocutory applications, whether for a stay or for an injunction or for an urgent permission to appeal, informally and very quickly. And please don't take my previous reference to a mystique as suggesting that we haven't already, some years ago when we moved to this building, reformed our rules and had in mind the need to streamline them and make them practical. So coming to particular cases, I can certainly think of, firstly, your near neighbours, St Kitts and Nevis, where we dealt with an important issue relating to electoral boundaries and a proposed change to them as a matter of urgency, issued our decision, reserved the written reasons till later and gave them later, and ensured a result whereby the election took place upon what we considered were the correct boundaries, which were the old boundaries rather than the proposed new ones. That's a case that attracted a lot of attention on video link. I think we had 5,000 hits when I gave the initial announcement of the judgment, and I think overall many more, a very large percentage of the population of St Kitts and Nevis. Another case we've had more recently over the Christmas and New Year involved, didn't come from the Caribbean, but it involved a series of urgent applications for stays, and it involved a hotel in Macau. In fact, it was an appeal. There was an offshore-owned hotel. So we do, I hope, rightly pride ourselves on dealing with that sort of application expeditiously and informally, and issuing decisions which really matter to the parties.